Someone breached your contract 10 years ago. You just found out. Can you sue them? Hi, I'm Michael Dorff, and I'm the Executive Director of the Lowell Milken Institute for Business Law and Policy here at UCLA School of Law. In the next few minutes, I'll explain the legal concept of statute of limitations and why waiting too long to sue for breach of contract sometimes kills your case. The statute of limitations is a legal deadline to file your lawsuit. If you miss the deadline, the case will be dismissed no matter how right you are. Timeframes vary by state, but typically it's broken down by the type of claim you have. Written contracts, most states, the statute of limitations is somewhere between 4 and 6 years. For oral contracts, it's generally between 2 and 3 years. Sale of goods contracts, it's 4 years. And for real estate sales, it varies from 6 years all the way up to 10 years. Again, the exact numbers depend on the state that you're in. When does the clock start ticking? Usually the clock starts ticking when the breach occurs or when you discover the breach, or at least should have discovered it if you were being reasonably diligent. For example, you signed a contract in 2020. In 2021, the other side breaches. You sue in 2024, probably okay. That's probably within the statute of limitations in most states. Can the clock of the statute of limitations ever be paused? Sometimes. There are actually a number of ways to pause the clock on the statute of limitations. First way, the defendant leaves the state. That makes it difficult or maybe even impossible to sue them. That pauses the statute of limitations. Second way, the plaintiff is a minor or mentally incapacitated. We don't expect minors to understand their rights, nor do we expect that of people who are mentally incapacitated. So the clock is paused for both of those groups as long as they remain within that status. Minor grows up, clock is no longer paused. Third, the defendant's fraud concealed the breach of contract. That's the defendant's fault. They're actively preventing the plaintiff from finding out about the breach. That will pause the statute of limitations. And finally, if the defendant acknowledges the debt in writing, that also pauses the statute of limitations. Why do we have this rule? Why can't we just sue whenever we feel like it once there was a breach of contract? Well, there are 4 rationales for having a statute of limitations. First, evidence gets stale over time, making it harder to pursue the claim. Second, witnesses disappear or die, again, making it a lot harder to evaluate whether the claim is valid. 3, we'll just need certainty at some point and some knowledge that there's not going to be some claim raised against them from 25 years ago. And finally, it encourages the prompt resolution of disputes. We all just want to move on, don't we? To sum up, you usually have somewhere between 2 and 6 years to sue for breach of contract, so don't wait. Have you ever discovered an old wrong when it was too late to sue? Comment below and follow for contract law that actually makes sense.